husband was earlier in India. Both were in India. He was a pilot. He was arrested on charges of 498A, etc. The criminal case has been stayed. So he is originally, their parents are from India, but he is born in the UK, citizen of UK. So he had to go to UK. He lost all jobs here because of this. And when it came for the evidence for the husband filed an application that I am in Canada, admittedly in Canada. Therefore, please permit me to lead my evidence by video conferencing. I joined a new diploma course in Canada, and the huge cost involved in traveling. He lost everything because of the, and since he is a UK citizen. And they sent an email where I was employed that there is a criminal case, etc. And immediately he was terminated. Now he cannot get a job. Now he's doing a diploma.
We will proceed with the video examination through video conferencing. If it's not working out for any of the difficulties, then we'll say that they shall be present.
The problem is any person being examined, including a witness shall, before being examined through video conference procedure, the file proof, everything has to be done is what is said. Then thereafter,
And is entering appearance for the wife.
today I have filed.
Petitioner is for the husband. Petition is the husband. My lord, the wife filed a petition for divorce, governed by the Indian Divorce Act. My wife's evidence over cross-examined. Husband was earlier in India. Both were in India. He was a pilot. He was arrested on charges of 498A, etc. My lord, the criminal case has been stayed. So he is originally, their parents are from India, but he is born in the UK, citizen of UK. So he had to go to UK. He lost all jobs here because of this. And now he is in Canada making further studies. His contention is, my lord, when he was arrested, etc., his all documents were taken back by the other side, and therefore he is not able to get any employment here. Now he has joined some course in Canada. Now the crux of this matter is this, Your Honor, that wife led her evidence.
Why?
Wife led her evidence in the divorce case, my lord. And when it came for the evidence for the husband filed an application that I am in Canada, admittedly in Canada. Therefore, please permit me to lead my evidence by video conferencing. And because I am there, so I want to lead my evidence. Well, the other witnesses I can examine if they are present here in India physically, but my evidence I want to record by video conferencing. I am not able to come when Canada and a huge expense are involved. This application is opposed, and that is dismissed. That is the crux of the matter, my lord, before my lord. The order is page 100, my lord. IA 8 is the application for video conferencing. 22/6/2024. Above application are filed by respondent counsel under section so and so and so and so Karnataka rules for VC and under order 26 rule 5 CP to record the evidence of the respondent through video conferencing and for appointment the commissioner to record the evidence. In the memorandum of facts, the London counsel of the respondent submitted. The respondent is residing in Canada, undergoing a diploma course. It is further submitted that if the respondent returns to India, there is a chance to register false criminal case by the petitioner. The respondent has no job and impossible to spend huge amount to travel to India. With these conditions, requested to allow the applications. Then the objections filed by the other side that he can come, he can do it, etc. And there are allegations against him. And therefore, there is no merit.
Oh, the manner in which the allegations that are leveled against the husband, I think he should come.
The problem is this, my lord, if after recording the evidence, one aspect is this, kindly examine this matter on this line. Now, video conferencing evidence, this can always be held in camera also. There's absolutely no problem. She wants to show some materials, it can always be displayed to him. That
No,
and
but
this,
for these kind of
please.
allegations that are made, a person has to be being in person and being through video conference makes a lot of difference.
her evidence was also recorded in camera only. Her evidence was all recorded in camera, and whatever the materials that she wants to project, there cannot be anything because she has not produced any materials.
Let the court give a particular dates on that day. You come down. And get
This
your
is there's one problem, my lord. The huge economic financial burden. I have lost job. Admittedly, there is a criminal case where it has been stayed and lost job. I cannot be employed anywhere. I joined a course there because I lost a job here. I joined a new diploma course in Canada, and the huge cost involved in traveling. I lost everything because of the, and since he's a UK citizen. And they sent an email where I was employed that there's a criminal case, etc. And immediately he was terminated. Now he cannot get a job. Now he's doing a diploma course. This financial cost may also be.
When will your diploma course will complete?
Diploma course will be completed. That's 2 years course. 1 year is over already. Now, as for the some months, how many months remain, we will inform the Honorable Court after getting specific instructions, my lords. That how much 2 years is to the course. Almost 1 year is definitely over. How many months, etc. is over. We will definitely inform the Honorable Court, my lords. Question 2. That
It's not 1 year it can't
Well,
wait.
1 year will not. The Honorable Court will not, my lords. I don't know.
Yes,
We will
what
ask.
do you say?
Well, so far as copy is concerned, I have not yet been served, but I will.
Today, my
receive
lord.
it. I will
What about
receive
you
it.
have instructions? It's a
I have-
simple
I have-
issue, don't have to file anything.
I have been told that there was a lot of adjournments which were taken. He was in India. Cross-examination also, there was a lot of adjournments and an application which I only moved before my lords for early disposal of the case got dismissed, saying that there are no delays. But these are the tactics which the husband is been using. That is the reason why I had approached. My lord might remember while sitting in the other court that it's the same parties.
Plus, he has been examined, cross-examined. He was not in India.
What is the stage now?
ಈಗ ನಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಟ್ಬಿಟ್ರು ಇದು ಕ್ಲೋಸ್ ಮಾಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್
This?
No,
Respondents.
ನಮ್ದು ಎವಿಡೆನ್ಸ್ ಸಾರಿ started speaking. I'm extremely slowly. Hope my lords, our words will reach my lord in the course of time. Each one, at least 1 or 2 words, my lord. This has become it has become a practice for us. It's so happened. I also once appeared, my lords, in
Respondents.
Hyderabad. I saw my learned friends speaking in the.
In Andhra and Telangana, generally advocates don't address in the local language.
No, but some words like this, one time or something like that, at the end, some words it comes like conversation. Please, my lords. Now, only
What has happened now, the cross-examination is over.
over, completely over.
It's for respondents' evidence.
At this stage, I said we have to.
Was posted for respondents' evidence is my instructions.
Hmm.
Thereafter, he did not appear and he filed this application for seeking video conference, and we oppose, saying that one aspect is
Divorce petition is filed by the wife.
How the by the way.
So his evidence, he's not yet commenced.
he is not.
I want
not
to
yet late.
lead my evidence in this. What is the document ಹಾಕಿದಲ್ಲ?
Yes, he has to
Will
come.
this-
Now, my lords, as far as
Come.
she has produced some documents, already produced. She is saying that he is guilty of something illicit, etc. All documents are already there. It's marked. They want to, at best, confront it and say this document is not a document is going to be produced anew, fresh. It's already on record. Those documents already, so the allegations already made, we have confronted it. There's nothing new. And these documents, we have
No,
documents are produced.
When you want to, want the early disposal, when you want an early disposal, what is the, just find out what is the difficulty in going through the.
Problem is, my lord, these video conferencing facilities also,
Because
there are
it's
so many, the
it's-
remote point and the court point and everything has to be determined. There has to be somebody there in the remote point as well, who is the representative, who will be the consulate, and the time gap, my lord, between Canada and India. While the courts are functioning here, that will be
That's-
night there. These all things are one complication which the court also observed while an application was considered,
Uh,
saying it is impossible and family court is not equipped.
No, Adi,
That's the
that has not been stated. I'm sorry.
No, that was
Impossible.
observation, what was made is
No,
what.
no.
Even
One-
otherwise.
One
like,
aspect, please.
No,
please.
the timeline, that is one issue.
We have a lot of family members, lot of Indians in Canada. My lord, this is, these days, we advocate sit at,
It's court timings.
no,
it's a
we
whole
advocate. No, my lord, this, as far as the video conferencing evidence is concerned, my lord, let it be recorded in Indian court timings. We have no objection. That will be a night for him, that's all.
But that has to be remote point, there must be somebody else. my lord. That is what the video conference rules say.
Plus Karnataka rules may I pass on, my lords.
Those rules, I think I have an occasion to see.
Please, I will pass on with it.
With regard to the criminal case and the other cases, there is a distinction?
Illa, sorry, no,
There's no discretion, except that it's in the
No, no,
common.
no, there is a distinction.
6,
Come to that rule.
Please, my lord, I am.
rule 8 is
producing the-
examination.
Hmm.
Please. Court, may I kindly definition 2 clause 4. Court includes physical court and virtual court. That maybe your lordship is referring to the rules in the CRPC. There is some.
No,
separate,
here,
please.
somewhere I think I saw. it.
Prepared for-
Rule 5, minutes. 5,
Rule 5.
5, preparatory arrangements.
Yes, In that, one aspect I beg to submit now itself, and rule 5.3, next page, page 206, at the top, overseas.
No, 5.1, you please read.
5.1, there shall be a coordinator both at the court point and the remote point from which any required person is to be examined or heard. However, coordinator may be required to at the remote point only when a witness or a person accused of an offense is to be examined. I stress on this. Only when, that's probably honorable court is. I am grateful, my lords. When a witness or a person accused of an offense is to be examined, not in other cases. In civil and criminal cases falling within the purview of the district judiciary, a person is nominated by the high court, etc. Coordinator for the remote point, it may be required. That is only in criminal cases. Here, matrimonial, there is no dispute about the identity.
5.2.
We'll read that also. In
The
the
civil and criminal
courts falling within the purview of the district judiciary,
Persons
persons nominated by the High Court or the concerned shall perform the function of the coordinator, the court point as well as a remote point
as
as provided in law, in rule.
Rule.
Maybe any of the following. Please come to that.
Coordinate
Page
the remote point.
overseas, official of the Indian consulate,
This overseas.
official of the Indian consulate,
Okay.
relevant to Indian embassy, relevant High Commission of India. First question is whether it is required. If the my lord holds it required,
No, if it is law, how this 5.1 and 5.2 has to be read?
There.
That's the whole question.
there is no decision of this court on this point. This is the, we have framed.
Passed one order in that, in one of the cases.
My lords has passed.
In one of the
We-
cases, I remember.
Report-
That's how I remember this provision 5.1.
We are grateful, will.
Reported.
There shall be a coordinator both at the court point and at the remote point from which any required person is to be examined on heard of. Coordinator may be required at the remote point only when a witness of a person. So what 5.1 says is no coordinator is at all required.
Criminal case.
Maybe in 5.2, then
Again,
there
there
is
is-
no meaning to 5.2.
Correct.
You should read there.
Because whatever
And
happens.
again, they speak about civil and criminal.
But one problem is, my lord, who is there to manage there? There must be somebody who will manage what sort of things are questioned and how exactly he behaves there. We don't know. Because
That-
further observations in the rule 8 says the court is empowered to make comments on the conduct of the witness. 8.
Let us see.
ಯಾವ್ದು? 8.
Oh.
No, before that, may I also pass on, my lords? We'll read 6.
8.6, my lord.
6. We'll read 6 then.
I'm sorry.
Please, 6. Procedure for video conferencing. Application for appearance, evidence and submission by video by conferencing. Any party to the proceeding or witness, save and accept where the proceedings are initiated at the instance of the court, may move a request for video conferencing. A party or witness seeking a video conferencing proceeding shall do so by making a request in the form prescribed in Schedule 2. Then one more point also, your lords may kindly, this may have to be decided by the Honorable Court. Any proposal to move a request for video conference should be first be discussed with the other party or parties to the proceeding, except where it is not possible or inappropriate. For example, so and so. Now, where the parties are fighting each other, heavily fighting, whether does it come because if literal interpretation is given, it would mean that both should consent.
No, we'll pass an order like this. Now you proceed with the video examination through video conferencing. If it's not working out for any of the difficulties, then we'll say that he shall be present.
The
before
problem
the
is 8, my lords.
court. 8 of?
8, rule 8.
Examination of
Any
proceeding,
person being examined, including a witness shall, before being examined through video conference procedure, the file proof everything has to be done is what is said. Then thereafter, 8.2, my lord, the person being examined will ordinarily be examined during the working hours of the concerned court or at such time as the court.
Correct. Indian court time only it has to be.
The oath will be administered to the person. And 8.6, my lord, the court would be at liberty to record the demeanor of the person being examined.
I think this thing will not arise in this.
Then once again, what happens, my lord, the whatever is typed in the court has to be sent by email to the person who is sitting there, and a printout has to be taken, signed in original and physical copy, and that has to be couriered or by registered post. But there must be somebody responsible. We can't leave it to the discretion of the witness. That is the reason why, my lord, reading all these provisions, I think there is
No, it's not 8.8.
8.8, my lord.
Yeah.
The court shall
Shall
obtain the
obtain
signature of the person being examined on the transcript once
That's
the
all.
examination is
The
concluded.
oath will be administered to the person being examined by the coordinator at the court point.
That,
Point.
No, court point, that has to be, then it has to be sent by email to that place. And the original printout has to be taken. I think it is 8.8.2. If digital signature,
All this has to be harmoniously read, otherwise entire thing will be rendered infructuous and
8.8 is how the procedure, my lord, how the printouts have to be taken.
yes, digital signature has to
Digital
provide it.
cover element, both the concerned court point and remote point. The soft copy of the transcript digitally signed by the presiding of judge at the court point shall be sent by the official email,
No, what we do is,
the remote point.
we'll just try that. If it is not, then will also pass an order saying that if through video conference, whatever is the difficulty and the court is not able to proceed, or it is not convenient to the party to examine him, then he should come in person.
My request, my lord, because once we leave it from here, once it goes there, people will fight it out tooth and nail. Because I know each and every person will blame each other, as my lord knows, because of the matrimonial disputes. I think we need to resolve something here itself so that something.
The other way around is, they will try to create a situation because of dispute, as my learned friend rightly puts it. One party may create a situation as if this will not work. That in the technological advancement, my lord, the human race cannot stop it. We are in advanced stage now. So nobody can say, my lords, this is creating any difficulty, because we have reached a stage where the honorable court is allowing the parties to speak before the honorable high court. So therefore, my lord, the provision has to be read in such a manner.
Request, my lord, if my lords could post it on Monday, I will file a formal statement of objections and assist the court to draw some conclusion on this point, so that it will be for
Instructions from the client
others also, it will be there, the guidance.
so that unnecessarily.
Please, I also
Will be
agree.
laid down.
Have
on
it on
that.
Tuesday.
The law may also be this some points.
Tuesday
Please,
we'll have.
please,
Please.
we will.
Until then, my lord, let the not be proceeded further, because it's
We will not
arguments.
proceed.
Anyhow, the matter will not come up, so.
Coming tomorrow.
When is it posted?
Tomorrow, my lord, then arguments and.
I will tell them.
Post this matter on Tuesday, facilitating the learned counsel for the respondent to file his objection. It is submitted that they'll not proceed with the matter. But the learned counsel for the respondent submits that they'll not proceed with the matter till Tuesday.
Respondent will not proceed.
Respondent till
please, please.
Tuesday.
Parties, both of us will not, my lords, proceed with the case.
You have already filed your wakalat.
Wakalat is already.
Learned counsel so submits that he has filed wakalat, the respondent so and so filed wakalat. Registry is directed to print his name.
Obliged.
Both the parties shall not proceed, my lords.
Please.
Grateful.